on WDXE News, on the air since 1951. This is The Legend. 105.3, 95.3, WDXE.
And we've made it once again to the Friday morning Stan Pierchoski hour. How about that?
Yes.
Good morning to you, my friend.
Good morning, Jeff. Good morning.
It's Friday again. Can you believe it?
It is, and if like the announcer said, you know, that we are the legend, and we've been on since 1951. I'm tired. No, it is Friday again, and time for the show, Bulletproof Estate Planning. And we talk about everything there is to talk about with estate planning. And
Absolutely.
This is a call-in show, so if anybody wants to share a thought or a question or experience, give us a call. Number is 766-9393, 766-9393.
Absolutely.
How was that for a radio voice?
Hey, you did good.
All right, hey, our seminar coming up. Next one, you know, I did one earlier this week. It was kind of a quasi-private seminar. I was invited by the Giles County Sheriff's Department.
Oh, yeah.
And I met with all them, and I had a pretty good turnout, very inquisitive bunch. I mean, I think it was an hour afterward I stayed answering questions, and they were very
Oh, wow.
inquisitive. So it was I think it was on Tuesday we did that. So, and you know, I'm available to do that, you know, depending on my schedule, but you know, people invite me to talk to the parishioners at a church.
Yeah.
Employees or employers not hire me, but bring me in to give a seminar to their employees, and things like that with the sheriff's department or just organizations. You know, homeschool group organizations have asked me to come in and stuff. So I'm available to do that. Schedule dependent, of course. I mean, we stay very, very busy. And they usually are out about a month or two in scheduling, but we're available to do that. But the next public one we're doing, where anybody can come, is right here at WLX radio station on May 17th. Now that's a Saturday, and Saturdays we do them at 10 o'clock in the morning. It's called Will's Trust in the Nursing Home, and that's what we're going to talk about. And it's going to be, like I said, in the back of the building here. The physical address here is 1212 North Locust Avenue, Lawrenceburg, Tennessee. So if you want to come to that, it is not too early to RSVP. We've already got quite a few, which is not a problem because it's a pretty big venue. And I was just looking while you guys were finishing up the last show. The door was open, and I walked into the area there, and I know they have that big TV hanging on the wall. Because I usually tote my big TV over and put it on the table.
Right.
And I was looking at that one, and I think it'll do. So I can just plug into yours and.
That's the way to do that.
I'll have to ask Charlotte, make sure that's okay, and plug in and use it for my PowerPoint. So it'll work out good. And it's up on the wall and it's raised up, so it's definitely people sitting in front of you aren't in the way of it. Which mine was just on a table level.
Yeah.
So that might work. So,
it's a good idea.
Yeah. So
very good idea. I'm sure you had a busy week.
I did.
Since I saw you last.
I did. It all seemed to be busy, and that concerns me sometimes. But I mean, it's good to be busy. Don't get me wrong. I mean, you got to I have to do something all day anyway. It may as well be this, right?
Absolutely.
We stayed busy, but it seemed like there was. I was busy with unique problems this week. So just things that when they came in, it's like I had to do a little research to figure the best way to deal with them, which is, which is challenging, but it's also a fun problem. You know. Yeah. I know one of my assistants, Miss Alex, was doing some deed work, and she ran into some very, very challenging deed work. The chain of title came out of an old partition sale, and there was like 11 tracts in one petition. It wasn't even in a deed. I mean, it was really unique, something she hadn't seen before. And we're walking through it. I sense she's calling. It was in McNairy in Chester County, so she's calling them and talking to them. And I could sense she was getting a little frustrated. Okay, trying to figure it out. And she said, "I'll get it," but I said, that reminds me of when I was in high school. I had an algebra teacher. I had him for algebra and I think advanced math, and I didn't like him. I have to admit, there are certain things to this very day that I remember that he taught me about math. You know what I mean? So he was good at that. Pains me to say that, but I give credit where credit's due. Anyway, he did say something I've always remembered, and it was the harder the problem, the more satisfying the solution. And that's what I told Alex.
That's a very good thought.
I know you'll crack this. I know you'll get it. When you do, you're going to feel real good about yourself for solving this, what seems to be an overwhelming problem right now. Yeah. But you'll get there.
That's a good thought.
Yeah.
That's a real good thought.
And I've been there. You get a math problem, it's just impossible, and you're picking away at it, you're thinking about it, you're sleeping on it, and all of a sudden you work it out, and boom, the light goes off, and you get to the answer, and it's like, yeah.
I had somebody give me a little bit of a good advice like that too. Kids, if you're having them do something, they may look at you and say, "This is hard." Well, the answer to that is to tell them you can do hard things. You can do hard things, and encourage that. You can do hard things.
And those are the fun things, really.
Yeah, absolutely. Absolutely.
No, and kids are like that. They balk at stuff when they think it's going
Yeah,
to be.
I don't want to do hard things. But the things that I have done that have been hard have been rewarding, just like
Yeah.
you're talking about.
I remember when my boys were in Boy Scouts and we did a 30-mile bike trip on the Natchez Trace.
Oh,
Like
my.
15 one
Yeah,
way,
that's a
15
pretty
back.
good trip.
It was an all-day thing. And my son was like, leading up to it, he's like, I don't know, he may have been, 14 or 14 years old or something.
Yeah.
He's like, Dad, do you think I can do that? He said, yeah, how long is 30 miles? He says, how long is that going to take? Do you think I can do that? I mean, it's going to be hard going up and down the hills. Just for days.
Yeah.
I'm sure I can do it. I said, all right, you can do it. You can do it. You can do it.
Yeah.
I said, just haven't ever done it before. That's the only problem.
Yeah.
Embrace it. And we had I was driving a pickup truck in the tail of everything.
Oh, yeah.
If I had to pick up a bike and a guy and take him to the top of the hill.
Well, they
I
call
would
that
do-
the sag wagon.
Right, and I would have the lights blinking to let people know on the trace that something was going on up ahead. But,
Right.
Well, my son and his friend were like always way out the head of the pack. I mean,
Yeah.
and he was so proud of himself. He said, "Man, that wasn't hard at all. It was great."
Yeah, good for him.
It's like you think it's hard, but you don't know what it is until you do it.
That's
and,
right.
And 9 times out of 10, it's going to be, hey, that wasn't near as hard as I made it in my mind to be.
Exactly.
I like to take the position, how hard can it be?
Yeah.
Other people do it.
Yeah.
I mean, I think myself, I'm at least average, so surely,
Yeah.
gosh, I can do it. I may not be able to do it as well, but surely I can do it.
That's a good segue into what we talk about here. You might think this is hard, and it is hard. There's some hard decisions you have to make, and when you do this estate planning.
Yeah, that's right.
But if you do these hard things, then it makes things easier down the road.
And I don't know that hard, but yeah, you're right. It's people think there's a lot to it.
Yeah.
The hardness is making the decision of what you're going to do with stuff and people.
Yeah.
And that's just something you have to weigh the pros and cons for. But yeah, it's not.
But that's the mental challenge. We think it's going to be hard.
Well, and because it's a legal thing, and people
Yeah.
get a little bit concerned because they don't know the ins. They don't get into the weeds of the legal part of it.
Right.
And that's okay. You need somebody to do that for you, just like anything else. Let's say if you had to go to court because you got a DUI or something. I mean, you have to get somebody that knows and understands the rules and procedure and stuff, and to represent you. You don't get into the weeds of that. You just
Right.
have a basic defense for whatever is going on.
Yeah.
And the same thing here. We talk about doing a trust, but there's quite a bit involved when I actually sit down and draft the trust. There's a lot of things that need to be in it. I mean, that's really when you hire me, that comes with what you hire me to do.
Right.
Is make sure the trust is working, will work when you need it to, complies with all our trust code and whatever it needs to be in compliance with. So, but you don't need to get into those weeds, but in this show, we do get into some of the weeds, at least a little more, because we have a whole hour to talk about stuff.
Exactly.
And I'm more than happy to explain how it works. Don't really expect people to run out and do it that way. That's not my goal. And I wouldn't advise that because you may understand basically how something works, but the actual nuts and bolts of doing it is where a mistake can be made. And that's where we don't want to make mistakes. So anyway, what I was going to talk about was something that I've been dealing with here the last week or two. And it came up quite a bit. And I think a lot of people have this question. And that is, if you have a trust, and let's talk about a couple, husband and
Okay.
wife. You have a trust. One of the questions is really what happens when one of them passes away, or what we call the first death of a couple, right? So, and the answer is really not much. Not much happens then. It's really kind of seamless. So we have this trust, and it's a joint trust, husband and wife, and they're both the trustees and they're both the trustors, kind of thing. That's typical. And so, what we do is we put our property into it, and it's our property is into a joint trust. It's just like it was when it was not in the trust, like it was joint. Okay, so at the first death, nothing really happens. I mean, there's no probate to do because it's in a trust, and there's nothing really passes from spouse to spouse. People
Right.
have reciprocal wills, and they usually always say, at my death, everything I have goes to my spouse. But if she predeceases me, then it goes to my children, okay, something like that. Well, in a trust, nothing really passes from one spouse to the other, and here's why. If you back up in time a little bit and go to the point where they don't have a trust, you have like a joint bank account, right?
Right.
You and Tracy have a
Yeah.
joint bank account, right?
Yeah, absolutely.
And so does my wife and I, and so does everybody else that's out there, typically.
Yeah.
And so when you have a joint bank account, what that means, let's say there's, I don't know, $500 in that joint bank account.
Yeah.
That means I can go in there and take that $500 out as soon as I get to the bank.
Yeah.
And I don't need the joint owner's permission at all. I'm an owner of the account.
Right.
There's two owners. It's not like $250 of it is mine.
Right.
It's all mine. And my wife could do the same thing. It's all hers. She can go in and take it out whenever she wants. It's a joint account. Both owners have 100%. They have equal right of entry and equal right of possession, which means they can go get it any time. Now, when you put it into a joint trust, it stays the same kind of posture. It's just in a joint trust. So when you have the first death of a couple, nothing passes. You just have one owner. So it's identical to that person because just like a joint bank account. If you have husband and wife and one of them pass away, now you just have one owner that has access to everything, which is exactly what they had prior to the death.
Yes.
It's just only one of you now.
Yes.
So there's no passing of assets from husband to wife in a trust. It's not necessary. It's kind of already theirs.
It's already there.
It's just you're not there either. So it's very smooth, very seamless at the first death. Now the only time anything would have to be dealt with at a first death, because even whether you have a trust or not, I tell people you don't often have to probate the first death because most everything is in joint ownership.
Right.
If you've been married any length of time, I'm willing to bet 99%, if not 100% of everything you own is joint. And then we have that, that joint ownership, the way it gets from one to the other.
Exactly.
But if there was something you owned on your own, let's just say you had this bank account, and it was just in my name, Stan's name, and I don't know why I didn't put it in the trust. It should have been in the trust, but I kept it out because it's my slush fund and stuff I piddle with and do this or that. Or I hear people say, "Well, I got this co-op account, and I'm going to keep that out of the trust."
Right.
I usually recommend might as well leave it in the trust. But if if at the first death that person has something titled in their individual name, then we would have to deal with that because it's not in the trust. So we have to make it go somewhere now, and that can be problematic. But we have Plan Bs that fix that. We have that pour over will in the trust that will catch it and will it to the trust and get it there. So we anticipate that may happen, but no reason for it to happen. When you have a revocable living trust, you put everything into it. I would recommend everything, and then everything passes probate free. And so it passes. It doesn't even, like I said, it doesn't even pass, but it's probate free. But when at the second death, because if you don't have a trust, let's just take a piece of property like you deal with,
yes,
the primary residence. It had a deed, and you're husband and wife.
Right.
The deed says, okay, Jeff, and it's Tracy or Teresa.
Teresa.
I
Jeff and Teresa.
I don't know where Tracy came from. It says Jeff and Teresa, and it may say husband and wife. It may not.
Yeah.
Whether it does or not, the default for husband and wife is you own it by right of survivorship.
Yes.
Okay. Now, at the first death, there's no probating of that piece of property of any kind, simply because all ownership instantly vests with the survivor.
That's right.
And you can have more than two people. You got 10 people as owners, and one passes away, the 9 own it, another one, the 8 own it, another one, the 7 own it.
Right.
But with the husband and wife at the first death, all ownership instantly vests with the survivor. So it doesn't pass by probate; it passes by right of survivorship.
Right.
Now, but at the second death, if you don't have a trust, it most assuredly goes through probate because now it's only owned by the survivor. And if it's in the survivor's individual name, then it's got to go through probate to pass. There's no other survivor for it to go to. It can't pass a second time that way, if there's only 2.
Yeah.
And so, but in a trust, it's a little different because now it's in the trust, and the trust passes things probate free.
Yes.
So that's what happens at the first death of a couple. I always get calls where people say, "Hey, Mom and Dad had this trust. Dad passed away. What do we do?" And the answer is kind of, not really anything. Yeah. Maybe the only thing to do is look through everything and see if there's anything entitled in Dad's name alone, and then we might have to deal with that.
Exactly.
But just for the most part, very little is, if anything, to be done at the first death.
Right.
Now, the second death is a little different. The second death now. The trust controls where the property goes, and we have somebody named a successor trustee.
Yes.
Their job really bubbles to life at the second death. Now, but they're already empowered with all the powers and duties of our trust code because they were named in the instrument when the instrument was drafted as the successor trustee. Right. So they have all the power and authority already. So at the moment of the second death, they can start distributing property, and they have the authority. They don't have to go to court and get the court swear them in like an executor and give them letters testamentary so they can actually act. They already have the power to act by virtue of the trust code where you appointed them maybe 20 years ago when you drafted the document. Yeah. And so they go to the trust, and they get that call too. Dad passed away, Mom passed away a few years ago. I'm the successor trustee, what do I do? And I say, well, let's go to the trust and take a look. It says everything goes to you and your two siblings, a third, a third, a third.
Yeah.
Your job is to gather up all the property, and then if it's money, write checks, divide by 3, write checks. If it's
Yeah.
real estate, we'll deed them, we'll do a deed that deeds them their 1/3 undivided interest or whatever, and just start handing it out.
Right.
Do I have to go to court? No, court has nothing to do with it.
Yeah.
Descent and distribution is controlled by the instrument, the trust instrument, not the court.
That undivided interest is interesting.
That can be cumbersome sometimes.
Yeah.
But it happens all the time.
Mhm.
It is probably the most popular way to do it.
It is.
And I don't know if it's always chosen to be the way to do it, but that's the way it ends up.
Yeah.
If you're not careful.
It's hard for some to understand. I was actually partners on a piece of property for a short period of time. And let's just say this is not what it was, but let's just say it was 30 acres and there was 3 of us. And I never could get it through one guy's head that he said, well, I own 10 acres of that. And I'm like, no, you own it all, and we all own it all. And it was like, no, I own 10 acres because I'm a third,
Yeah.
and we never could get it through his head. It was like, we're all joint,
Yeah.
owners of the whole, and everybody owns the whole thing.
Let's talk about that, because that comes up all the time,
Yeah.
and you explained it pretty well.
Yeah,
But let's say you have 3 people.
Yes.
That was the example, right?
Yeah.
3 people
Yeah.
had a 1/3 undivided interest. Each, okay?
1/3 undivided interest.
You own that as tenants in common,
Uh-huh.
which means you all have what is called equal right of entry and equal right of possession.
Yes.
So what that means is you, Jeff, one of the owners, can do whatever you want with 100% of the property.
Right.
Owner number 2 can do whatever he wants with 100% of the property.
Yep.
Owner 3 can do whatever he wants with 100% of it. There's no lines drawn. You all own all of it,
Right.
which, as I'm explaining it, and as you explained it, if you're listening, you can start to see where there might be some difficulty.
Yeah.
If you all are using it for a common purpose, that's well and good. But let's say you decide you want to farm it,
Yeah.
and owner 2 wants to build an amusement park. I mean, the two are inconsistent goals,
Right.
They can't coexist.
Right.
So now we have a problem. What's it going to be? Well, I don't know. We got to resolve the conflict, right?
Right.
Now, the only thing when you own this 1/3, the only time that's ever going to come into play is if you sell the property, you get 1/3 of the proceeds.
That's exactly right.
But the equal right of entry and equal right of possession gives everybody complete ownership of everything. Now, when you have that title, I'm going to go a little farther with this. When you have a title and you're one of those 3 people, the courts consider that an unmarketable title. And here's why.
Okay.
Let's just say you have this 1/3.
Yeah.
And you say, you know what, I don't want this 1/3 anymore. I want to sell it.
Yeah.
I mean, you couldn't sell it on the open market. I mean, nobody's going to buy with 1/3 interest with 2 other people that they don't know.
Yeah.
With equal right of possession, equal right of entry, right? I mean,
Yeah.
nobody's going to do it. Really, the only purchaser that would want to buy from you would be one of the other 2. Those are the only ones that would really have any.
Usually, yes.
I mean, I can't see it going any other way. I mean, if somebody bought it, they'd be out of their mind, unless they had something in mind. But so it's kind of unmarketable in the open market.
Yeah.
So if you really want to sell, and the other 2 either can't or won't buy you out, they
Yeah.
can pursue a partition action.
Yeah.
A partition action is when you go to court, and the court will force the sale or draw lines.
Yeah.
They'll do one or the other. They can partition in kind, which means they'll look at it, they'll draw lines and say, this is your 1/3, now here's your 10 acres, this is your 1/3, and this is your 1/3, and here's the meets and bounds description.
Yeah.
The statute is do that first if you can, but that is a hard thing to do, because look at all the things you have to factor in. You have to factor in road frontage, water, if you have a piece of property like that, there's maybe a house and it's going to reside on somewhere.
Yeah.
If we start drawing lines, the house is going to change the value of one, or all kind of stuff like that. It's very, very difficult to draw these lines.
Yeah.
And so the court, more often than not, will force a partition sale, which means they'll force everybody to sell it and divide the money.
Yeah.
And first of all, that's a cumbersome legal process. It's
It's
very lengthy.
And one of the owners could potentially buy it.
Absolutely. At any time.
Even at a forced sale.
At any time, they can offer the person, they can buy it by agreement. I put that in my trusts a lot. When somebody leaves one piece of property to 3 children, I'll leave what's often called the right of first purchase, which is any one of the other children, if you elect to sell it, or elect to dispose of it, before you try to pursue a partition sale or a sale on the open market, the trustee has to allow the other owners the first opportunity to purchase you out.
Yeah.
And you can come to an agreement on that. In other words, typically they're supposed to do it for fair market value. But if you get together and your brother and say, look, I know this is worth $100,000, but I'll give you 80, and how about if I just give you 80? And if you agree to that, you can do it. Or you can do this. You can say, look, I don't have the 100,000, but I'll give you 30,000. I'll give you 30,000 a year for 3 or so years, or over time. And if the person will agree to that, it's okay.
It's all negotiable.
Yeah, it's all negotiable. Or you can pay fair market value if that's what they want.
You'll be surprised to know, probably based on what you said, that I've actually sold an interest in a property like that.
You mean as a realtor?
As a realtor.
Oh, there you go.
There was sold a 1/3 interest in a piece of property like that.
Well, we move them all the time, like move them into trusts and stuff. And so, I tell people when you have a trust, you can only put into it what you own, and if you only own 1/3 of the property.
It was highly unusual. It was a different kind of deal, but it did happen one time.
I had a case one time where a gal owned it, and a couple of her siblings owned it that way.
Yeah.
And I told her, you can put that piece of property in the trust, but we can just put your interest in trust. I said, the others are just going to own it, instead of owning it with you, Jane Doe, they're going to own it with Jane Doe's trust, right?
Yeah.
And it doesn't disturb their interest one iota.
No.
So we did. We put that, I think it was 1/3, we put it in, and now it was brother 1, brother 2, and sister's trust with the owners.
Yeah.
And she got a call from her brother who was just livid about it.
Yeah.
And I think he'd called me and just like, I want that changed back. I did not agree to that. I don't want to. I said, very nicely, I said, don't really need your agreement because we didn't disturb your 1/3 in any way, shape, or form. You still have exactly what you had prior to what happened.
Yeah.
And he just insisted we change that. And we just said, I can't remember. I think my client said, I think we ought to just change it because that's what he wants. But I think we held our ground and said, no, it doesn't affect anything. I mean, I think he probably went to an attorney. The attorney said, you don't really have a standing to demand that because you still own exactly what you owned
nothing
before.
changed.
Yeah, you still got everything. I think that's where he was misled, was he thought, well, that's going to affect something.
Yeah, I'm sure he thought.
Being in the sister's trust.
I'm sure he thought so.
Being in the sister's trust, it's still kind of the sisters, so it's even more so. But you're right, that 1/3 interest can get kind of sticky.
I mean, let's say that me or you one had an interest, a 1/3 interest in a piece of property, and we wanted to give it to our child.
Sure could.
So you could transfer your 1/3 interest, and it doesn't disturb the other.
That's right, and that's an inheritable asset. Whereas you have right of survivorship, you can't leave that to somebody because at your death, it goes to the other person.
Yeah.
See the difference? I mean, there's a big difference. One has an asset. At your death, you own 1/3 of this property. You can say, I would say, I leave this to my kids.
Yeah.
Now, brother 1 and brother 2 are going to own it with sister's 3 kids.
Yeah.
So that's an inheritable asset. Now you can also own it. You can also own it with fractional ownership as joint tenants. Okay.
Yeah.
Meaning, I have they usually do it in tenths or hundreds, and they can say, I own 3 tenths, you own 3 tenths, and the other person owns 4 tenths.
Yeah.
Or whatever, you can have this fractional ownership. Works the same because it's still an undivided interest. It just comes to bear whenever you actually sell the thing that you only own that much of the value.
Okay. With right of survivorship like this, what happens? Let's say if I own a 1/3 interest with my 2 siblings.
Okay.
And this piece of property is with right of and I pass away. It just automatically goes to both of them and not my heirs.
No, it depends on how you own it.
Okay.
If you own 1/3 undivided interest, it goes to your heirs. It's something you own. It's a asset that belongs to you.
Okay.
It's like your car. Or
But
money
there is a form of ownership though where it goes to the survivors on the deed and doesn't go.
Okay.
Now, where is that?
Excellent question. Very misunderstood.
Yes.
When you're husband and wife, it's automatic right of survivorship.
Yes.
It's called tenants by the entirety with right of survivorship. Okay. It's automatic, whether you say in the deed you're husband and wife or not.
Right.
If you are married when you acquire the deed, that's the default value.
Right.
Now, you can have right of survivorship with a non-spouse. That's what we're talking about.
Right.
You can have right of survivorship with a non-spouse. However, the deed has to have the language that it's right of survivorship as joint tenants and not tenants in common.
Not tenants in common.
And if you have that, then you're right. Now, if the 3 of you own it that way, and one of you pass away, now the other 2, again, all ownership vests with the survivor or survivors.
Okay.
And now they own it all. Now they don't own a half now. They never owned a 1/3. They never owned a half. They own it all.
Right.
just together, okay? And so now it all resides with those two, and then when one of them pass away, it all resides with the survivor. So that, but yeah, what you're dealing with is right of survivorship with a spouse or right of survivorship with a non-spouse. The only difference is if it's a non-spouse, the deed has to say it, has to have that language. If it doesn't, it is fatal.
Fairly rare, I guess.
I've done it a few times, but yeah, it's out there. It's out there. I mean, it really depends on exactly what you said. What do you want to have happen to it at your death? If you want it to be something that you leave to your kids, you don't want right of survivorship because it's not there for you to leave to your kids.
Right.
If you want to leave it to your kids, then you want to leave it as some, some fractional ownership or this undivided interest.
Right. Interesting.
Yeah.
So many angles. So many angles.
Well, that's right down your
Yeah,
wheelhouse.
it is. It is.
But it is that is, I was trying to think, there was a case where somebody was absolutely positively sure that that's how they owned this piece of property. And so I said, well, until I get to look at the deed, I really can't tell you whether you do or don't.
Right.
They were just convinced. They were just like, don't even bother looking at the deed. I know that's the way it is. So I pulled the deed because I so often see the language not there. And sure enough, it wasn't.
Yeah.
And I pointed it out to them, I explained it to them, and they were just shocked. But I mean, it's a fixable thing. Suppose you and these three people owned it 1/3 undivided interest. You say, you know what? Let's own this as right of survivorship, right? You just have another deed made up, and the deed is like this: the grantor is going to be A, B, and C, each of 1/3 undivided interest each. Quitclaim 2, A, B, and C, right of survivorship as tenants in common and not joint tenants. Or, okay, you know what I mean?
Yeah.
And now, with that deed, you now own it with right of survivorship.
Wow.
You did convey ownership.
Yeah.
You did affect the ownership.
Right.
So it has to be a conveyance from the way it was to the way you want it.
You mentioned something there that
It's
just
a
kind
solvable problem.
that makes me think that we sometimes do make wrong assumptions about the way something is, especially with these legal matters and legal documents, things like that. I see it sometimes with people think that a will is a certain way or the state's a certain way or boundary lines are a certain way and they're not. There's so many times that we see it and it's not like they think it is.
Yeah. Gosh, I make wrong assumptions with my wife all the time.
Yeah, I do too. Well, we may have
sure.
we may have a call to take.
Go ahead,
Let's see if
Ryan.
we got one.
I'll take some coffee.
Hey, good morning. You're on WDXE with us.
Yeah, what if you already give it to your kids and put it in their name, your farm or your house, and for like 8 or 10 years ago? What
Okay.
happens when I died in? Is it all up to them or?
Well, I'll let Stan answer that, but you've already given it to him, right?
Let me ask
Stay with us.
Let me ask the question. What was the purpose of giving it to him 8 or 10 years ago?
What did he say?
What was the purpose of giving it to him when you did 8 or 10 years ago?
Well, just so they'd have it when I'm gone.
Yeah, okay.
Yeah, I mean, here, pretty simple. You gave it to them 8 or 10 years ago when
Whoops.
okay. Well, we'll go ahead and answer.
Yeah.
Okay, 8 or 10 years ago, the property was deeded to the child, it sounds like.
Yes.
Or children, I don't know
Right.
if it was singular or plural, but it was deeded to his subsequent generation, right?
Yes.
And so ownership was complete at that time.
Right.
The ownership is defined by the deed. It was, I mean, so it's a done deal. Since then, they've owned the property.
Right.
Now, some people will reserve a life estate where there's some,
Yes.
where somebody maintains, keeps, they give it the property, or they give the property away to them, but they retain the present possessory interest, and that's called a life estate. I mean,
Right.
that could exist or it could not exist, but in this case, he didn't say that, so I'm assuming he just gave it to him. Ownership was complete. So, I mean, the question is, he said, what if you do that? The answer is, that's what happened.
Yeah.
But it also is, you know, if the reason I said why did you do it, because if the reason for doing that was maybe we're concerned about the long-term care issue.
Right.
The fact, you know, giving you can do that. You can give it away anytime you want.
Right.
But if you're doing it for long-term care purposes, you're going to get stuck with this 60-month period where they can impose a penalty period on you if you give it away and then 60 months of asking for benefits.
Right.
Then in this case, that's come and gone. So it's free and clear.
Right.
There's nothing they can do. In other words, it's the kid's property.
Yeah.
I mean, now Dad can't come back and say, "Hey, I gave this to you, but it's really my
So in
property."
his particular case, 8, 10 years ago, there's really nothing they have to do and nothing changes.
No, I mean, it was theirs then. It's theirs now.
Yeah.
And now if their long-term care comes into the picture, It's outside the jurisdiction of them to do anything about that.
Yeah.
And the only thing they could do is impose that penalty period we talk about.
Right.
And they can't do that now because they can only, because if he wanted 10 care, he would like apply today, and they can only look back 60 months from that application, and they wouldn't see that something happened 8 years ago.
Right.
So,
right.
you're golden, the person, the caller, you're
Good
everything's
shape on that one.
As long as that's what you want, that's what you got. That's
Yeah.
exactly, no problem. There's nothing can be done about that by anybody.
Yeah.
But it does bring up two concerns, when people do that. A lot of people will do that, but let's back up 8 years ago, okay?
Yeah.
I don't know the family, and don't get mad at me, but I'm just using this for example.
Yeah.
And you say, okay, I'm gonna give it to my kid.
Yeah.
I'm just gonna deed it to him for love and affection, $10, just a token consideration, and give it to him.
Yeah.
You can do that. But once you do that, and let's say it's your home,
Yeah.
the primary residence, if the child wants to once he owns it, it's his.
Yeah.
They do whatever you want with it. Just like you could do whatever you want when you own it.
Right.
So when they own it, if they want to turn around and give you the boot, they can because they own it, right?
Right.
It's not like, well, wait a minute, I gave this to you so I get to live here. No, I'm the owner. Get off. You can do that. Now I'm picking on the kid. I know
Yeah.
they wouldn't do that, but so people who may have a slight concern about that because it's not the child sometimes. The things you might worry about is like maybe who the child marries or
Yeah.
something that comes up that really is not. You think, well, the child would never do that, but for some other things. Anyway,
Yeah.
so sometimes people will say, to protect my interest in this, I'm going to reserve a life estate so I
Right.
can live there for the rest of my life.
Exactly.
Now what we've done is we gave the property to the child, but not all of it. We gave him the future interest, and he's called the remainderman. And we retained for ourselves the present possessory interest.
Yes.
Okay, so I'm going to be there now, living on, possessing it until the day I die.
Right.
Now, the way it works is at my death, or at the life estate person's death, the life estate expires worthless, and all ownership now vests with the remainderman. He now has the future interest that he had in the first place, and now
Right.
he also has the present possessory interest,
Right.
and everything that goes with it. So we have when you have land, you got a bundle of rights. They tell you in law school.
Yes.
And so when you deed it to a child, you give them the whole bundle, but you take one of the sticks out of the bundle and you're going to keep it for yourself, and that's the right to live there for the rest of your life.
Yeah.
But at death, that stick goes back to
Yeah.
the child, and then they have the whole bundle.
Right.
And so now some people do that, and that is not a complete gift because if you run into issues like long-term care, they will put value on that asset, that life estate.
Oh, yeah.
I mean, it's like, okay, well, how do they know how long I'm going to live? Because that affects value, right?
Yeah.
And so, well, God bless them, the government has a table. They will go and look at your age. Well, they'll go and look and see how old were you when the transfer took place. Let's say it was a $100,000 house.
Yeah.
They'll figure out the value the day of transfer, and they'll say, okay, and there's a little chart that gives the life estate value.
Yeah.
Believe it or not, you go
Yeah.
down to this chart to age, and there's two columns. One says the remainder interest, one says the life estate.
Right.
They're two fractions, they're two decimals, and magically the two of them add up to one in every column, right? In every row. And so whatever the remainder value is what you gave away, which is typically hovers around 60%. And what you retain is the life estate, which is 40% interest. Now, as you get older, that value of the life estate dwindles.
Right.
And of course, like I say, and then at death expires worthless. Now, that's okay. A life estate's an old common law form of action,
Yes.
firmly rooted in our system of jurisprudence. But it is, when you're dealing with long-term care, it can be a cumbersome asset because it is an asset, for one thing. Okay? And when you try to qualify for 10 care, it's all about assets and income. And it's a cumbersome one because if you give it away, it's a gift. If you give it away, they're going to go to that table and go to your age and say, okay, this is what you gave away. Right? Because when you gave it to the kids, the remainder thing was a gift.
Right.
It just wasn't the whole value of the house. It was $60,000 instead of the whole 100.
Right.
And so that's a gift. So that's a problem. Now you can't sell a life estate. In other words, if somebody comes to me and says, hey, I got a life estate in this property.
Right.
Do you want to buy it? I'm going to say, well, I don't know what to pay for it. How long are you going to live? I don't know how long I'm going to live. Well,
Yeah.
that's seriously going to affect what I want to offer to pay for it.
Right.
If you're going to live another 50 years, the price is much lower than if you're
Right.
going to be out of here in less than a year. So you can't. Now, again, the only person that would ever buy a life estate would be the remainderman.
Yeah.
But now you have that money. That's a value that you have because you can't undersell it either. You have to sell it for fair market value.
Yeah.
It's a cumbersome asset when you're dealing with long-term care. there's ways to deal with it, and that's a little more in the weeds, but I'm just saying, there's ways to deal with it, but you have the right to live there, but the 10-care system puts value on that, puts a dollar figure on that,
Yeah.
whether you like it or not. So
It's interesting.
so it's so like I said, the collar's in great shape. Everything's done. As long as that's what he wanted, then that's the result he got. There's no strings attached to that anymore, because for any reason that I can even think of.
Yeah, yeah,
But it does belong to them now. If they start doing something with the property that he doesn't like, he's just out of luck because it's not his anymore.
yeah,
But you know what I mean. It's like it's just like he sold it to somebody else.
Yeah.
It's just not his anymore.
Yeah.
But that's
but that was his desire.
well, and now here's something. He did it a long time ago, and everything's great.
Yeah,
A lot of people wait until they got an issue with health
yeah,
or long-term care is starting to be this thought process,
yeah,
and they say, "I need to hurry up and give this away."
yeah,
Now, obviously, this gentleman did not give the property away for what we call to artificially impoverish himself.
Right.
Or he didn't do it for 10-care eligibility purposes.
no,
That's what this 5-year rule is all about. The 5-year rule says if you give anything away in the last 60 months from the day you ask us for help, right? The presumption of the law is that you did so
yeah,
for eligibility purposes.
Yeah.
In other words, you did so to artificially impoverish yourself and say, I'm applying for 10-care, I don't have anything. Where'd it go? Oh, I gave it all away. Well, if you gave it all away so that you wouldn't have anything, so that you could apply for 10-care, that's a problem.
yeah. And that's what they're
Or
looking for.
at least it's a problem in the last 60 months of your life
Right.
from that day. Doing it that long ago, I'm sure the guy wasn't contemplating long-term care. I mean, maybe he was, but I'm just saying. Usually, people that do it a while back, that's not what they're contemplating.
Right.
If you do it in contemplation of that, then you got this magic 5-year period that you got to worry about.
Yeah, yeah,
And that's why it's there, because 99% of those kind of transfers are for that reason. I mean, let's just face it, that's why people do
Sure,
that.
sure.
And it's often done late in the game.
yeah.
And so that's why that 5-year can be such a problem.
And that's why you do what you do, is to address that in a way that helps them retain their property and see that it goes the way they want it to go.
So, I mean, the caller got exactly what he wanted, but he had to give it away.
Yeah, yeah,
But it's protected.
yeah.
Now, there's another way to give it away, exact same result. Let's just say instead of deeding it to his children,
Okay.
he deeded it into one of those asset protection trusts that we do, that income-only asset protection trust.
Right.
He would have given it away 8 years ago.
Yeah.
Because he divested himself of it and put it in the trust.
Put it in the trust.
He has this limited access to principal and all that and stuff like that now. But all this time, he has control of that property.
Right.
Okay? He hasn't completely divested himself of ownership.
Right.
He doesn't have access to principal, but he has complete control of it. So he can farm it and do whatever he wants to do with it. And still, he can put in that trust that says, hey, in my death, this goes to the child he gave it to, right?
Right.
And now the person's going to get that. They'll get it at death. They'll get it just as free and clear and just as protected. But if your goal is to use it and maintain it during your lifetime, just flat out giving it away to a child may not be the best solution. In this case, it sounded like it was the best solution. But if you still want to maintain control of the property, you want to make sure they still get it.
Yeah.
Then we give it to a trust that we have control over.
Yeah.
So there's a slight twist on that. It would end up with an identical result if we'd have done that 8 years ago. And if long-term care enters the picture, it's like, hey, this stuff was given away. Same thing. It was all given away a long time ago. Nothing you can do about it. So there's a lot goes on.
It does.
Especially when especially if your interest lies in the long-term care end.
Sure.
Because we have to deal with it. It's not that a lot of changes are made, but we constantly have to deal with the government just deciding what they're going to do on a whim and doing it.
Yeah.
I am dangerously close to involving my congressman and doing a class action against 10-care for something they've started doing and now has become a pattern, and it is just wrong. It's just
really?
not correct. And I've gone to fair hearings, and now the administrative judges are saying, well, they're approving it. And it's completely in distinction to what the statute says. So, I mean, it's going to say, look, I mean, we need a court to come in and say, is this right or isn't it? I mean,
Yeah.
here's why I get frustrated about it. I know the rules. I mean, I spent hours and hours and hours, I deal with them all the time. I know the rules. When you have a set of rules, what's the purpose of a set of rules? It's to create an expectation of all the parties.
Right.
So when I have a piece of property, I have a married couple trying to get qualified for 10-care, I know we have this thing called the resource assessment period where one spouse can just give everything to the other one, and they have a 12-month period to do that to become, that's what the rules say.
Right.
So when I go in there and they say, well, no, he's not eligible because he doesn't have less than $2,000. And I say, well, but he has, you have to do a resource assessment first, and then everything he owns, we can show that we'll give that to the other spouse, and we'll do it in the grace period that the 10 Care Act has of 12 months, and they'll be eligible. They say, well, we're going to treat him, basically they're saying, we're going to treat him like a single person, we're going to deny eligibility. Had that happen a couple of times.
Yeah.
And that's not what the statutes say. It's just not, and so I have this expectation of what to do, and when I do it and they change their mind about it, then we get a result we weren't expecting because of what they're changing the expectation.
Yes.
And so, now we got this situation where I'm trying to get other attorneys that have the same problem. I'm part of a forum that I talk to other Tennessee attorneys, and we're trying to get a group together and several clients, and I think we're gonna go to them and say, look, if you guys are gonna continue doing this,
right,
we're gonna file a class action thing and get the courts to say, hey, this is what the rule says. Why
right,
are you doing something other than the rule? What authority do you have,
yeah,
10 Care, to do what the rule doesn't say you can do? They don't. And if that's the check and balances of government. If they're starting to, I don't want to say go rogue, but I don't. They won't explain to me why they do it. They just do it. And so they can explain to the court why they're doing it.
Yeah.
And I don't think they can come up with a good explanation.
It doesn't sound like it.
You look at the motor vehicle code. It says you have to come to a complete stop at a stop sign, right?
Yeah.
You see the ambiguity in that statute.
It's pretty black and white.
I think so too. It's pretty straightforward. So
now I violate that rule a lot.
I understand, but when you do it, it's a violation of the rule.
It's a violation of the rule.
So, but now it's like, well, it's okay just to roll through it because, well, I can see pretty far in both directions and nobody's coming. So
right,
I didn't stop, but it was a safe not stop, right?
Yeah.
Well, which is right, which is wrong? Well, the answer is clear. Stop means stop. If they meant stop when somebody else is there, stop, but if nobody, a statute has to be clear, it can't be ambiguous. And that's why they're pretty much cut and dry like that. So it's the same kind of situation. It's like you guys are interpreting something. I don't even know, you won't even share with me what your thought process was, because I'll explain, point out where you're doing it wrong.
Yeah.
But anyway, it gets frustrating, and it's exciting to do that. It's just frustrating dealing with, it's like, I shouldn't have this problem.
Right.
The rules are the rules. I shouldn't have a problem with somebody else interpreting the rule.
Yeah.
But anyway, it is what it is, and it needs to be corrected, and so we'll go through the proper, redress of grievances and procedure that
Well,
there is
keep us
when you have a
posted
problem.
on that. I'm interested in see if you actually, form that
Might be
action.
a while. Might be a while, and you don't have to have a very big class. I could probably do it with just I got about 4 or 5 clients. I could do it. Class doesn't have to be a certain size.
Yeah.
I can be however size. Now, I'm not very experienced in my law career in class action lawsuits. I know of them. I got a general understanding of them. I've never done one. It's just a special kind of law that I've never participated in. So we'll probably have to get somebody else involved with the actual litigation on that. But like I said, I know how to develop a class and create the issue.
Right.
I just never have been involved in litigating it because like I say, it's a unique area of the law to do.
Wow.
And then you got to give notices and stuff. And there was one just done with 10 Care that changed their way of thinking. That was resolved in 2023. It had to do with their computer system because a lot of people were being denied for recertification as a result of COVID. And their new system, which is called the TED system, which is a computer system, and they got hammered pretty hard on that one. So I would think the threat of another class action might get their attention. So we'll see. If it doesn't, if it doesn't, then we'll go. And if the courts say, yeah, what they're doing is great, then I'll have my expectation back and say, okay, now I know what to do. I don't agree with it, but I'll do what they're telling me to do because that's the court now has ratified the rule that they're using.
Yeah.
So I'll say, okay, now I know what to do. I don't mind doing things if I know what to do.
Yeah.
But if a rule tells me to do it this way and the other side does it another way, and then it ends up being to my detriment, it's like, okay, there is an ambiguity there. And that's a very definition of an ambiguity.
Yeah.
So let's take away the ambiguity and make it definitive. What is expected of me when I file an application with this married couple?
Yeah.
Tell me and I'll do it.
Yeah.
But
Well, they've already told you.
But go down on
changing
record.
the rules.
Well, go down on record as that now being the new rule.
Yeah. Yeah.
I don't think anybody has any problem doing it as long as we know what to do.
Well, based on a lot you've told me, it seems like that system up there is somewhat fluid in things that they do.
It's a government operation. I don't know that I really need to say much more. You know, and I hate that. I mean, you could be, you know what I wish? Here's what I wish. I think it would be very helpful. You know, now with the administration in the age of Doge, right? The age of government efficiency, which I think is a super magnanimous thing to do.
Yeah.
I think if a state were smart, like Tennessee,
Yeah.
they would just create their own T-Doge.
Yeah.
Tennessee Department of Government Efficiency.
Yeah.
And
Yeah.
here's a place where efficiency would be appreciated, because it doesn't exist. It would
Yeah.
clean it up a little bit. I mean, it's just the way systems get. When they get big and a lot of people are involved, and sometimes it's just the way it gets. Corporations get that way, you know what I mean? It needs to be, that's my little world, but it needs to be done probably in other areas of Tennessee government as well. I think the individual states should, because the Doge we have now is all federal. They're not gonna come to Tennessee and clean up TennCare for me.
No.
But the same concept, I think, is great. We need somebody that will analyze the efficiency of how government acts.
Yeah.
Because any inefficiency gets to be expensive for the
Very expensive.
the individual citizens. Because that's how you pay for government.
Yeah.
Till Trump comes along, then he pays for everything with tariffs. And there's money left over. I mean, which is how, this is how they used to do it in the early 1800s.
Oh, yeah.
100% of the revenue of the country came from other countries.
Yeah.
I mean, it's a beautiful thing.
It's gonna be.
It's what they're for.
It's been fun to watch.
It's written directly into the Constitution. They call them duties, imposts, and tariffs. There's
Yeah.
3 different things. Tariffs are just one of the things you can do. You also have a duty and an impost. I'm not going to use that on this show. That's not what we do. But if you want a homework project, go look it up.
Interesting.
They're similar instruments, but they're not the same as a tariff. But they're things you do with fair trade.
How about that?
Yeah. So, and it's written right in the Constitution. So anyway, but yeah, I think I don't know how to make things more efficient. I wish I did. I just try to work with them as best I can. And usually we're very successful, but we're always successful. It's just sometimes we have these stumbling blocks that we have to get around and to get to the successful end result. Where I don't think we should have these stumbling blocks. I think it should be a straight shot through. I don't have to go around the tree. I should be able to go right through where the tree is.
It seems there's definitely inconsistency sometimes in how you get rulings.
But again, in the last couple of minutes here, that is a prime reason why people come to me and say, I'm just going to do my own TennCare application, or I'm going to do the application for Dad myself. The do-it-yourself application, now I would never, I'm not one to tell people, oh, you need a lawyer. You need a lawyer to do anything with the law. That's not true. You don't need a lawyer to do anything. Yeah. You could defend yourself against a murder case if you wanted to. Courts wouldn't stop you. They advise you a million times. It's probably not a good idea, but that you can do it. Yeah. But this is an area of the law, for all the reasons I say and all the reasons I deal with on almost a daily basis. It's not a good idea, because when they change their mind, now your only argument is, hey, here's what the rule says, and you're not following it, which means you got to know that, which I do. Right. But an average do-it-yourself on an application probably doesn't. Yeah. They say, well, shoot, they just denied me. I don't know what to do about that now. Right. So how are you gonna appeal something if you don't know what they did wrong and don't know what they should have done if they did it right to argue to the appellate court? Right. And that's where the problem comes in. Not only is it complicated in the first place, they've kind of convoluted it further with the way they do business. Yeah. And so it's hard anyway. So it almost seems like it's purposely hard to navigate. Sometimes you'd think that, wouldn't you? Yeah. It does kind of look that way. Now, I don't know. I'm not a fly on the wall, and I don't want to accuse them of anything, but you kind of wonder, how else could it get that way? But it does. I think any government operation, end result is this disarray and confusion. And that's the cleanup that it needs, Yeah. I don't think they're gonna affect the money and stuff like that. They might tighten the purse strings out, because for places, maybe they're paying money in places where they shouldn't be. Right. So I mean, I'm all for cleaning up the eligibility and make sure you're paying for people who are eligible. It's like the concept where they find sending Social Security checks to people that don't exist. Yeah. That's not efficient. That's a windfall to somebody. Yeah. It's not efficient. So tighten them up, purse strings up for that, and get rid of paying that. So if you got people who are getting TennCare benefits and they really don't meet the eligibility standards, that shouldn't happen. Right. But for people that are eligible, which is kind of what we do all the time, they should get what they're entitled to. Right. And just clean that kind of stuff up. But I don't think they're going to take any money away from the system. It's funny is how the government entities like that, you've got on the one hand, you've got money just flowing out to places it doesn't go, and then you got places where it should be going and it's not going. Or it's tightened up. Or it's tightened up or something. Listen, we're coming down the home stretch, so let me talk about the seminar coming up May the 17th. Saturday, 10 o'clock in the morning. Wills, Trust, and the Nursing Home is what we call it. Right here at WLX radio station in the back of the building. Come through the double doors in the back of the parking lot.
Yep.
And we do that on the 17th. Call my office at Pierchoski Estate Law, Pierchoski Elder Law at 931-363-7222 to RSVP.
Yep.
It's a very informal process. Just tell us you're coming and how many. That's good enough. Then just show up. And if you can't RSVP to the last minute, or just don't worry about it, just pop in. We accept walk-ins, no problem. So if you have any questions, feel free to call me or go to my website, Estate Plan Stand, and you can get my email and ask a question that way if you want, or or see where the seminars are. You can see my calendar and do that.
You got a great website, by the way. I was looking at it on my phone here while we were talking.
Okay.
And you've got a great website, Estate Plan Stand. You can get more information there, find out about him and his office and the services that are there. And of course, located on the square there in Pulaski, next to the Star Theater.
Yeah.
Beautiful square and a busy square.
Yeah, we are always here on Friday mornings from 8 to 9 with this show. So if you want
That's
to
right.
discuss something like the caller did, had a question, I think we answered it.
And the free seminar, May 17th, right here at the WLX Country Cafe.
Free educational seminar.
That's
I like
right.
to focus on the word educational.
That's
But
right.
there's no obligation whatsoever. Come and
That's right.
come and listen, stay, leave, do whatever you want. We'll have some light refreshments. Help yourself.
363 is the number, 363-7222, estatePlanStand.com. It's always good to have you, buddy.
It's always
Every
good.
Friday I look forward to it, and I always seem to learn a little something.
That's why I say education.
That's what it's all about.
It's slow. It always sinks in eventually, right? Even at our age, right?
Yeah, yeah.
See you next week.
See you next time. Let's see. I've got about 30 seconds here before we actually have to.
Well, let me say in real 30.
Yep,
I'm going to
yep.
be out of town next week.
Are you
Probably
really?
won't be able to even do a phone in on the
Okay,
call.
we'll
So
do
I'll
an
talk to you
encore.
about. You can do a recorded one.
Yeah, we'll do an encore presentation next Friday. That's good to know. So I guess from 2 weeks from now we'll have you back live, but there will be one show for next Friday as well.
You can stick a picture of me here on this chair.
That's right. Or maybe I've gotten so good at it, I'll just do it for
There you go. There you go.
So-
Thank you.
Broadcast services of Prospect Communications.
And just remember that I'm going somewhere and I'll be driving back Sunday afternoon. I won't get until late Friday night. So I forgot. So and just.